The Felgenhauers reopened their restaurant in June of 1982. Deliveries resumed over the bank's parking lot to the restaurant's back door. In November of 1984, the Felgenhauers sold their restaurant business, but not the real property, to James and Ann Enlow. The Enlows leased the property from the Felgenhauers. Deliveries continued over the bank's parking lot. James Enlow testified he did not believe he had the right to use the bank's property and never claimed the right. Enlow said that during his tenancy, he saw the bank manager in the parking lot. The manager told him the bank planned to construct a fence to property 398. Define the boundary between the bank's property and the Felgenhauers' property. Enlow asked the manager to put in a gate so that he could continue to receive deliveries and have access to a trash dumpster. The manager agreed. Enlow guessed the fence and gate were constructed about 3 years into his term. He said, 3 years could be right, but it's a guess. In argument to the jury, the Sony's counsel said the fence and gate were constructed in January of 1988. The Enlows sold the restaurant to Brett Butterfield in 1993. Butterfield sold it to William DeCossey in March of 1998. DeCossey was still operating the restaurant at the time of trial. During all this time, deliveries continued across the bank's parking lot. The Sonys purchased the bank property, including the parking lot in dispute in 1998. In 1999, the Sonys told the Felgenhauers tenant, DeCossey, that they were planning to cut off access to the restaurant from their parking lot. The jury found the prescriptive period was from June of 1982 to January of 1988. Discussion. The Sonys contend there is no substantial evidence to support a prescriptive easement for deliveries across their property. They claim the uncontroverted evidence is that the use of their property was not under a claim of right. At common law, a prescriptive easement was based on the fiction that a person who openly and continuously used the land of another without the owner's consent had a lost grant. California courts have rejected the fiction of the lost grant. Instead, the courts have adopted language from adverse possession in stating the elements of a prescriptive easement. The two are like twins, but not identical. Those elements are open and notorious use that is hostile and adverse, continuous and uninterrupted for the 5-year statutory period under a claim of right. Unfortunately, the language used to state the elements of a prescriptive easement or adverse possession invites misinterpretation. This is a case in point. The Sonys argue the uncontroverted evidence is that the use of their property was not under a claim of right. They rely on the testimony of James Enlow that he never claimed he had a right to use the bank property for any purpose. Ch11, Easements 399. Claim of right does not require a belief or claim that the use is legally justified. It simply means that the property was used without permission of the owner of the land. As the American law of property states in the context of adverse possession, in most of the cases asserting the requirement of a claim of right, it means no more than that possession must be hostile, which in turn means only that the owner has not expressly consented to it by lease or license or has not been led into acquiescing in it by the denial of adverse claim on the part of the possessor. 3 Kastner, American Law of Property. 1952, Title by Adverse Possession, 5.4, p. 776. Enlow testified that he had no discussion with the bank about deliveries being made over its property. The jury could reasonably conclude the Enlows used the bank's property without its permission. Thus, they used it under a claim of right. The Sonys attempt to make much of the fence the bank constructed between the properties and Enlow's request to put in a gate. but Enloe was uncertain when the fence and gate were constructed. The Sony's attorney argued it was constructed in January of 1988. The jury could reasonably conclude that by then the prescriptive easement had been established. The Sonys argue the gate shows the use of their property was not hostile. They cite Myron v. Smith, 1931, 117 Cal.App. 355, 362, 4p.2d 219, for the proposition that to effect a prescriptive easement the adverse user must unfurl his flag on the land, and keep it flying, so that the owner may see, if he will, that an enemy has invaded his domains, and planted the standard of conquest. But Myron made the statement in the context of what is necessary to create a prescriptive easement. Here, as we have said, the jury could reasonably conclude the prescriptive easement was established prior to the erection of the fence and gate. The Sonys cite no authority for the proposition that even after the easement is created, the user must keep the flag of hostility flying. To the contrary, once the easement is created, the use continues as a matter of legal right, and it is irrelevant whether the owner of the servient estate purports to grant permission for its continuance. Notes 1. Fiction of the lost grant. Felgenhauer refers to the fiction of the lost grant. The principle traces back to English law. 4-34 Powell on Real Property 34.10. Property 400. In early England the enjoyment had to have been from time immemorial, and this date came to be fixed by statute as the year 1189. Towards the close of the medieval period, this theory was rephrased and an easement of this type was said to arise from a grant, presumably made in favor of the claimant before the time of legal memory, but since lost. The usual American approach is to ignore the fiction and simply apply rules of prescription that largely track those of adverse possession. CID 2. How do the elements of a prescriptive easement differ from the elements of adverse possession? Why do you think they differ in this way? How do the resulting interests differ? 3. Easements acquired by the public. What happens if city pedestrians routinely cut across a private parking lot? May an easement by prescription be claimed by the public at large? Does it matter that the right asserted is not in the hands of any one person? Here, too, the fiction of the lost grant may play a role in the willingness of courts to entertain the possibility. There is a split of authority as to whether a public highway may be created by prescription. A number of older cases hold that the public cannot acquire a road by prescription because the doctrine of prescription is based on the theory of a lost grant, and such a grant cannot be made to a large and indefinite body such as the public. C2. American Law of Property 9.50, J. Kastner ed. 1952. The lost grant theory, however, has been discarded. W. Burby, Real Property 31, at 77, 1965. In its place, courts have resorted to the justifications that underlie statutes of limitations, the functional utility in helping to cause prompt termination of controversies before the possible loss of evidence and in stabilizing long-continued property uses. 3. R. Powell. Supranote 5, 413, at 34, 103, 04, W. Burby, Supra, 31, at 77. Restatement of Property ch. 38, Introductory Note, at 2923, 1944. These reasons apply equally to the acquisition of prescriptive easements by public use. The majority view now is that a public easement may be acquired by prescription. 2. J. Grimes, Thompson on real property. 342 at 209, 1980. Ch11, Easements 401. Dillingham Commercial Covey. City of Dillingham, 705 p.2d 410, 416, Alaska. 1985. What then should the owner of a publicly accessible location do? The owners of Rockefeller Center reportedly block off its streets one day per year in order to prevent the loss of any rights to exclude. David W. Dunlap, closing for a spell, just to prove it's ours. New York Times, October 28, 2011, available at http://www.newyorktimes.com/2011/10/30/New York region /lever-house-closes-once-a- year to maintain its ownership rights.html _r equals 0, but there is another significant hybrid, purely private space to which the public is customarily welcome, at the owner's implicit discretion. These spaces include Lever House, Rockefeller Plaza and College Walk at Columbia University, which close for part of one day every year. Another option is to post a sign granting permission to enter, thus negating any element of adversity. Some states approve this approach by statute. Cal. Civ. Code 1008, no use by any person or persons, no matter how long continued, of any land, shall ever ripen into an easement by prescription, if the owner of such property posts at each entrance to the property or at intervals of not more than 200 feet along the boundary a sign reading substantially as follows: right to pass by permission, and subject to control, of owner, Section 1008, Civil Code. Image by Brian Costales, used under a Creative Commons Attribution 4.0 International License. 4. Irrevocable licenses. Property 402. An easement is distinct from a license. A license is permission from the owner to enter the land. Because it is permissive, it is revocable. Many difficulties with distinguishing easements from licenses arise when parties fail to clearly bargain over the right to use land. See, example Willow Tex Incorporated v. Dimokopoulos, 503 N.E.2d 99, 100, NY 1986, the writing must establish unequivocally the grantor's intent to give for all time to come a use of the servient estate to the dominant estate. The policy of the law favoring unrestricted use of realty requires that where there is any ambiguity as to the permanence of the restriction to be imposed on the servient estate, the right of use should be deemed a license, revocable at will by the grantor, rather than an easement. Under the right circumstances, a license may become irrevocable. Richardson v. Frank. 182 Cal.RPTR.3D 853, Cal App 2015. Ruvolo, P.J. In order to access their home in Novato, California, James Scott Richardson and Lisa Dunity, respondents, had to traverse land belonging to their neighbors, Greg and Terry Frank, appellants, on a 150-foot-long road which was authorized by an easement for access and public utility purposes. Over a 20-year period, both respondents and their predecessors in interest maintained landscaping, irrigation, and lighting appurtenant to both sides of the road within the easement area without any objection. 6 years after purchasing the property burdened by the easement, appellants demanded that respondents remove the landscaping, irrigation, and lighting on the ground that respondents' rights in the easement area were expressly limited to access and utility purposes, and the landscaping and other improvements exceeded the purpose for which the easement was granted. Respondents brought this lawsuit seeking, among other things, to establish their right to an irrevocable license which would grant them an uninterrupted right to continue to maintain the landscaping and other improvements. In 1989, Karen and Tom Poxay began building their home on undeveloped property at 2513 Laguna Vista Drive in Novato, California. The project included constructing and landscaping a 150-foot-long driveway within the 30-foot-wide easement running down to the site of their new home, which was hidden from the Chap11, Easements 403 Street. The driveway was constructed pursuant to an easement over 2515 Laguna Vista Drive, which was then owned by appellant's predecessors in interest. The easement was for access and utility purposes only. Landscaping along the driveway was important to the Poxays. They hired a landscaper, who dug holes for plants and trees. Ms. Poxay then added plants and trees along both sides of the driveway in the easement area: hawthorn trees, Australian tea trees, daylilies, Mexican sage, breath of heaven, flowering pear trees, and evergreen shrubs. The landscaper installed a drip irrigation system. Water fixtures were also installed along the driveway for fire safety. The Poxays also added electrical lighting along the driveway, later replacing the electrical lighting with solar lighting. During the decade that the Poxays resided at the property, Ms. Poxay regularly tended to the landscaped area, including trimming and weeding, ensuring the irrigation system was working properly, and replacing plants and trees as necessary. In addition to Ms. Poxay's own labor, the Poxays paid their landscaper to perform general maintenance. Respondents purchased the property in late 2000. Over the years, respondents added new plants and trees, including oleanders, an evergreen tree, another tea tree, Mexican sage, lavender, rosemary, and a potato bush. Respondent Dunity testified that landscapers came weekly or every other week, and the landscapers spent 40 to 50% of their time in the easement area. During her testimony, respondent Dunity explained, "We've paid a lot of money to nurture it and grow it. It's beautiful. It has privacy. It's absolutely tied to our house value. It's our curb appeal." Appellants purchased 2515 Laguna Vista Drive in 2004. Appellant Greg Frank admitted he knew about the landscaping in the easement area, as well as the hiring of landscapers. He even admitted that the trees were beautiful and provide a lot of color, and were just all around attractive. From 2004 to August 2010, appellants and respondents lived in relative harmony. It was not until late 2010, approximately 6 years after appellants bought the property and 2 decades after the landscaping and other improvements began, that appellants first raised a concern about the landscaping and other improvements. Prior to that date, no one had ever objected. Property 404. In late September or early October 2010, without any notice, appellant Greg Frank cut the irrigation and electrical lines on both sides of the driveway. He cut not only the lines irrigating the landscaping on the easement, but also those irrigating respondents' own property. The water valve pumps leading to the irrigation lines were disassembled as well. As part of these proceedings, the trial court granted respondents' motion for preliminary injunction and the irrigation system was restored. Following a bench trial and an on-site visit to the property, the court granted respondents' request for an irrevocable license. As appellants acknowledge, the grant of an irrevocable license is based in equity. After the trial court has exercised its equitable powers, the appellate court reviews the judgment under the abuse of discretion standard. Before we address the specific issues appellants raise on appeal, it is helpful to review the law governing the grant of an irrevocable license. A license gives authority to a licensee to perform an act or acts on the property of another pursuant to the express or implied permission of the owner. 6 Miller and Starr, Cal Real Estate, 3D ed. 2000. Easements, 15:2, p. 15, 10. A licensor generally can revoke a license at any time, without excuse or without consideration to the licensee. In addition, a conveyance of the property burdened with a license revokes the license, id at pp 15, 10, 15, 11. FNS. Omitted. However, a license may become irrevocable when a landowner knowingly permits another to repeatedly perform acts on his or her land, and the licensee, in reasonable reliance on the continuation of the license, has expended time and a substantial amount of money on improvements with the licensor's knowledge. Under such circumstances, it would be inequitable to terminate the license. In that case, the licensor is said to be stopped from revoking the license, and the license becomes the equivalent of an easement, commensurate in its extent and duration with the right to be enjoyed. A trial court's factual finding that a license is irrevocable is reviewed for substantial evidence. In the paradigmatic case, a landowner allows his neighbor the right to use some portion of his property, often a right-of-way or water from a creek, knowing that the neighbor needs the right to develop his property. The neighbor then builds a house, digs an irrigation ditch, paves the right-of-way, plants an orchard, or farms the land in reliance on the landowner's acquiescence. Later, after failing to make a timely objection, Ch11, Easements 405. The landowner or his successor suddenly raises legal objections and seeks to revoke the neighbor's permissive usage. In the instant case, the statement of decision states, because respondents adduced sufficient evidence at trial concerning their substantial expenditures in the easement area for landscaping, maintenance, care, and physical labor, and because sufficient evidence was presented at trial to support that respondent's predecessor in interest, Ms. Poxe, also expended substantial sums in the easement area for landscaping, maintenance, care, and physical labor, and because, as the evidence and testimony at trial showed, that no objection was made to any of this by either appellants or appellant's predecessor in interest, Mr. Schaefer, over the course of more than 20 years, respondents have sufficiently met the requirements for an irrevocable parole license for both respondents and respondents' successors in interest. Both law and equity dictate this result. Appellants contend the trial court erred in finding the evidence supported the creation of an irrevocable license because respondents' reliance on continued permission to landscape and make other improvements in the easement area was not reasonable as a matter of law. Appellants point out the evidence at trial revealed that throughout the history of the ownership of the property, there was never an actual request for permission to make and maintain these improvements, and express consent was never given. In essence, appellants contend that tacit permission by silence is insufficient to create an irrevocable license, and that respondents were required to show an express grant of permission induced them into undertaking the improvements within the easement area. Permission sufficient to establish a license can be express or implied. A license may also arise by implication from the acts of the parties, from their relations, or from custom. When a landowner knowingly permits another to perform acts on his land, a license may be implied from his failure to object. Here, the undisputed evidence revealed appellants failed to object to the landscaping and other improvements for 6 years before appellants first made their demand that the landscaping and other improvements be removed. Thus, with full knowledge that the road providing ingress and egress to respondents' property was landscaped, irrigated, and lit, and with full knowledge that respondents were. Property 406. Maintaining these improvements on an ongoing basis, appellants said nothing to respondents. When coupled with the previous 14 years appellants' predecessors in interest acquiesced in these improvements, this constituted a total of 20 years of uninterrupted permissive use of the easement area for the landscaping and other improvements. Therefore, we find the court had ample evidence to conclude that adequate and sufficient permission was granted to respondents by appellants to maintain the extensive landscaping improvements on either side of the roadway. Appellants next stress that for the license to be irrevocable, there must be substantial expenditures in reliance on the license. In this regard, the trial court made the necessary findings that respondents have expended substantial monetary sums to improve, maintain, landscape, and care for the easement area, including the retention of professional landscapers on a regular basis. Appellants next challenge the unlimited physical scope and duration of the license granted by the trial court. They claim the trial court, in derogation of equity and the law, decided that our respondents should have sole and absolute discretion to decide what will happen on property that is owned by appellants. In making this argument, appellants ignore the fact that the trial court was vested with broad discretion in framing an equitable result under the facts of this case, as it was empowered to do. The trial court exercised its broad equitable discretion and fashioned relief to fit the specific facts of this case. The court found by a preponderance of the evidence that respondents hold an irrevocable parole license for themselves and their successors in interest to maintain and improve landscaping, irrigation, and lighting within the 30 wide and 150 long easement. Appellants assert it is wholly erroneous and grossly unfair to make the license irrevocable in perpetuity. Original italics. Appellants argue that a proper ruling in this case would be to grant respondents an irrevocable license, but with the license to landscape and garden limited in duration until respondents transfer title to anyone else or no longer reside on the property. The principles relating to the duration of an irrevocable license were stated by our Supreme Court over a century ago, and these principles are still valid today. An otherwise revocable license becomes irrevocable when the licensee, acting in reasonable reliance either on the licensor's representations or on the terms of the Chap11, Easements 407 license, makes substantial expenditures of money or labor in the execution of the license, and the license will continue for so long a time as the nature of it calls for. As explained in a leading treatise, a license remains irrevocable for a period sufficient to enable the licensee to capitalize on his or her investment. He can continue to use it only as long as justice and equity require its use. 6 Miller and Starr, Supra, 15:2, p. 15. 15. The evidence adduced at trial indicates respondents and their predecessors in interest expended significant money and labor when they planted and nurtured the landscaping abutting the roadway, installed sophisticated irrigation equipment throughout the easement area, and constructed lighting along the roadway. Under such circumstances, the trial court did not abuse its discretion in concluding it would be inequitable to require respondents to remove these improvements when the property is transferred, given the substantial investment in time and money and the permanent nature of these improvements. Lastly, we reject appellant's hyperbolic claim that in fashioning the scope and duration of the irrevocable license granted in this case, the trial court, without exercising caution, took property that rightfully belonged to appellants and ceded it to our respondents and their successors forever. This argument ignores that a license does not create or convey any interest in the real property, it merely makes lawful an act that otherwise would constitute a trespass. far from granting respondents an exclusive easement amounting to fee title as appellants claim, the court's decision simply maintains the status quo that has existed for over 20 years and was obvious to appellants when they purchased the property a decade ago. Notes and questions. 1. The restatement characterizes irrevocable license situations as a servitude created by estoppel. Restatement 2.10. Is there any difference, then, between an irrevocable license and an easement by prescription? Is there any reason to treat them differently? Property 408. 2. Is landscaping important enough to justify the intrusion into property ownership interests? What do you think would have happened had the appellants won? 3. How well does Richardson track your intuitions about everyday behavior? Would you ask permission before engaging in the landscaping at issue here? Would you advise a client to? Suppose you asked your neighbor for an easement of way to enable you to build on an adjoining property? You're friends, and he says yes. But you know a thing or two about the law, so you know that if your relations turn sour you would have to rely on an irrevocable license claim. Would you push for a formal grant in writing? Is that a neighborly thing to do? For 1. View, see Shepherd v. Purvine, 248 p.2d 352, 361-62, or 1952, under the circumstances, for plaintiffs to have insisted upon a deed would have been embarrassing. In effect, it would have been expressing a doubt as to their friend's integrity. Does it make a difference that you know to ask? What about those without legal training? Should the law accommodate private ordering or funnel property holders into formal arrangements? Do the interests of third parties, including possible future purchasers of each of the affected properties, matter to your analysis? C. Altering easements. Brown v. Voss. 715 p.2d 514, Washington 1986. Brachtenbach, Justice. The question posed is to what extent, if any, the holder of a private road easement can traverse the servient estate to reach not only the original dominant estate, but a subsequently acquired parcel when those two combined parcels are used in such a way that there is no increase in the burden on the servient estate. The trial court denied the injunction sought by the owners of the servient estate. The Court of Appeals reversed. We reverse the Court of Appeals and reinstate the judgment of the trial court. A portion of an exhibit depicts the involved parcels. Ch11, Easements 409. In 1952 the predecessors in title of Parcel A granted to the predecessor owners of Parcel B a private road easement across Parcel A for ingress to and egress from Parcel B. Defendants acquired Parcel A in 1973. Plaintiffs bought Parcel B on April 1, 1977. And Parcel C on July 31, 1977, but from two different owners. Apparently the previous owners of Parcel C were not parties to the easement grant. When plaintiffs acquired Parcel B, a single-family dwelling was situated thereon. They intended to remove that residence and replace it with a single-family dwelling which would straddle the boundary line common to Parcels B and C. Plaintiffs began clearing both Parcels B and C and moving fill materials in November 1977. Defendants first sought to bar plaintiffs' use of the easement in April 1979, by which time plaintiffs had spent more than $11,000 in developing their property for building. Defendants placed logs, a concrete sump and a chain link fence within the easement. Plaintiffs sued for removal of the obstructions, an injunction against defendants' interference with their use of the easement and damages. Defendants counterclaimed. Property 410. for damages and an injunction against plaintiffs using the easement other than for Parcel B. The trial court awarded each party $1 in damages. The award against the plaintiffs was for a slight inadvertent trespass outside the easement. The trial court made the following findings of fact. 6. The plaintiffs have made no unreasonable use of the easement in the development of their property. There have been no complaints of unreasonable use of the roadway to the south of the properties of the parties by other neighbors who grant easements to the parties to this action to cross their properties to gain access to the property of the plaintiffs. Other than the trespass, there is no evidence of any damage to the defendants as a result of the use of the easement by the plaintiffs. There has been no increase in volume of travel on the easement to reach a single-family dwelling, whether built on Tract B or on Tax Sic B and C. There is no evidence of any increase in the burden on the subservient estate from the use of the easement by the plaintiffs for access to Parcel C. 8. If an injunction were granted to bar plaintiffs' access to Tract C across the easement to a single-family residence, Parcel C would become landlocked. Plaintiffs would not be able to make use of their property, they would not be able to build their single-family residence in a manner to properly enjoy the view of the Hood Canal and the surrounding area as originally anticipated at the time of their purchase, and even if the single-family residence were constructed on Parcel B, if the injunction were granted, plaintiffs would not be able to use the balance of their property in Parcel C as a yard or for any other use of their property in conjunction with their home. Conversely, there is and will be no appreciable hardship or damage to the defendants if the injunction is denied. 9. Ch11, Easements 411. If an injunction were to be granted to bar the plaintiffs' access to Tract C, the framing and enforcing of such an order would be impractical. Any violation of the order would result in the parties back in court at great cost but with little or no damages being involved. X. Plaintiffs have acted reasonable sic in the development of their property. Their trespass over a little corner of the defendant's property was inadvertent, and de minimis. The fact that the defendant's counterclaim seeking an injunction to bar plaintiffs' access to Parcel C was filed as leverage against the original plaintiff's claim for an interruption of their easement rights, may be considered in determining whether equitable relief by way of an injunction should be granted. Relying upon these findings of fact, the court denied defendants' request for an injunction and granted the plaintiffs the right to use the easement for access to parcels B and C as long as plaintiffs' sic properties, B and C, are developed and used solely for the purpose of a single-family residence.